Worried about where your next meal will come from if the power is out for an extended period of time? I'd like to suggest Numana Foods, a family-owned business with a passion for food quality and taste, as well as long-term storage reliability. Numana.com. Check them out for your family's health and security. Food so good tasting and good for you, it can be eaten every day. Standard buckets are GMO-free, contain no aspartame, high fructose corn syrup, autolyzed yeast extract, chemical preservatives, or soy. You can be confident your Numana meals will be there for you and your family when you need them during an emergency. Numana.com, a nutritionally healthy way to prepare for any disaster. That's Numana.com. Numanna.com.
Food prices have increased over 40%. Energy prices have increased over 20%. Wheat and gas prices have increased over 70%. What's going to be next? Do you see these trends reversing or even stabilizing? All fiat currencies have always failed and collapsed their economies on their way down. The Roman Empire, China, France, Argentina, Finland, Mexico, Russia, and Zimbabwe all tried fiat currency and all collapsed into chaos. Meanwhile, the dollar has lost over 97% of its gold value since 1971, when an ounce of gold was valued at $35. If your assets are in paper, you are in danger. Protect your assets with gold and silver. Visit Discount Gold and Silver Trading at dgscoins.com. That's dgscoins.com, or call 1-800-375-4188. That's 800-375-4188. Protect yourself and your family.
Ladies and gentlemen, I'm Alfred Adask, and this is the American Independence Hour for Tuesday, 23rd day of May, year of our Lord 2017. Our guest tonight is Glenn Winningham of the House of Fern, and he will be joining us shortly as soon as I get done with my evening disclaimer. First, I'm a man made in God's image, as per Genesis 1:26 through 28. Second, I'm endowed by my Creator with certain unalienable rights, as per the second sentence of the Declaration of Independence. Third, I'm one of the people of the state of Texas, a member state of the Perpetual Union, styled the United States of America. Fourth, I have repeatedly pledged my allegiance to the United States of America. Fifth, I'm broadcasting from within the borders of the state of Texas. Sixth, I'm acting at arm's length. And seventh, I deny that I voluntarily agreed to act as fiduciary or surety for the government of the United States. Having said all that, we're going to bring Glenn Winningham, House of Fern, on the program. Glenn is one of the most, I don't know if he would agree or object to me calling him a member of the Patriot community. Glenn, is that something that you find acceptable, offensive, irrelevant? What do you think about being a member of the Patriot community?
Well, I think it's an honor, quite frankly. Thank you very much.
Well, some people would quibble about one word or another. Everybody in the Patriot community has a stack of dictionaries. Instead of the Patriot community, it should probably be the dictionary community or whatever. But you are certainly one of the most prolific authors of both documents and videos in the Patriot community, and you've been at it for at least 10 years, I'd guess. And am I roughly correct?
Well, I first learned about this back in the early 90s, and I've done aerospace engineering consulting all my life, and the guy that originally brought this to me, I told him he was nuts. And this was back in the early 90s, but then he showed me some court cases, and so I had to look into it from that point. And I thought, man, if this is true, this is the most fantastic thing there is. And I had to look into it, and so that's really when it started. But then in about 2007, I got a hold of some of Rice McLeod's material. A friend of mine recommended it. And I started really, I knew there was something wrong. I just couldn't put all the pieces together, and that kind of put all the pieces together about, what to do and how to do it.
Most people that get into what we can call the patriot movement or the legal reform movement, most of us get there because we went through a divorce, or we got tangled up in some traffic tickets, or we got tangled up with the IRS and we didn't like the result. And that caused us to start studying the law and try to make sense of it. From what I'm understanding of you right now, you're saying you didn't really go through one of those traumas. That didn't cause you to start studying. You were just kind of brought into it with a certain amount of curiosity. Is that true?
Well, Well, quite frankly, the bottom line is I've always felt that the Constitution was inspired by God, and if you think of that, then if you get involved in what could be viewed to be a contract to give up your God-given rights, I mean, that's like an insult to God. Yep. And so, to me, it's always been, yeah, exactly. And so it's always been an issue of, do I want to offend God, or do I want to be doing what He wants me to be doing? And so that's really, but I got to tell you that I certainly had my battles, and my attitude is it's never over till you say it's over,
I agree. I'm reminded of the story of Esau and Jacob in the Bible. Esau comes back from perhaps the war or whatever. He comes back, he's hungry, and Jacob offers him, he asks Jacob for a bowl of pottage, and Jacob says, yeah, I'll give you the pottage if you give me your birthrights. Those birthrights, ultimately, they come from God. All right? That's my understanding. And later in the Bible, on 2 occasions, God says, and Esau I have hated. And He never says why in the Bible, but I believe the reason He hated Esau is because Esau turned his back on the gift from God. And it was a kind of blasphemy, a kind of insult, exactly what you're talking about right now. And it made God angry, and Esau, later on, he came to regret that he'd ever turned his back on the rights that God had given him. And I think that's a lesson for all of us, especially if you start with that Declaration of Independence. We hold these truths to be self-evident. All men are created equal and endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. You turn your back on those God-given rights, you are essentially insulting God. And I don't think things will go well for you if you do that. So I understand where you're coming from, and I don't doubt that we probably have a great deal in common, and at least in terms of our motivation. And tonight we're going to talk about land patents, which is something I don't know much about at all. I'm just beginning to study the concept, and I know that you've been through 3 videos. I think it was back in 2011. Am I correct?
Yeah, I think 2011 is when I first. What happened was that friends of mine in Canada actually recommended that I set up a YouTube channel, and they suggested I set up a Google group. I wasn't really big on that kind of stuff because I've always been, concerned about people about being monitored like the NSA does, and but I went ahead. It was more of the fact that I needed to do things to educate people because people are pretty well asleep at the wheel, and so I started. I created, it was 2011, and that's when I basically started publishing my videos, and that was the first one back then, or the first ones, And I published them up as recently as, within the last 6 months about land in particular.
Copies of these documents can be found in my private group at Yahoo called Administering Your Public Servants. For a complete set of YouTube videos with private information shares, a DVD with over 50 searchable law dictionaries, and other books and forums, contact me privately at engineerwin@yahoo.com. And donations to support this work are appreciated. I prefer gold or silver coin. This last paragraph for all the Satanist order follower revenue officers operating in their private capacity under the Federal Tax Lien Act of 1966, because I prefer gold or silver coin. But as an extremely less desirable alternative, I can accept the IOUs, the Federal Reserve notes, the PayPal gifts, the checks, the money orders. Send me an email for particulars.
Then you are still, that was one of the things I'm curious about. And in fact, before we go any further, my co-host is Frank Steffen, and he's here, hasn't said anything yet, probably waiting for me to introduce him to you. But Frank, how you doing?
Pretty good. Kind of hot,
all right.
But,
Do you have are land patents something that are of interest to you?
Well, yeah, actually a big interest, not as much currently as they once were. I lost 5 acres of land pursuing a land patent. So, yeah, I was involved in it, and, it's of great interest to me. So, yeah.
Well, I'm just beginning to get interested in it, and it's kind of an external. I don't have any land. I don't have a dog in this hunt, but it's still beginning. I know one thing,
and I'm not familiar with our guest's information at all, so this isn't talking about him because I don't know either way. But I know one thing: there is a lot of information that isn't right about land patents floating around.
Well, people have telling me about land patents at least 20 years. I've been hearing about them, and I have not been able to identify anyone who absolutely knew what he was talking about and could produce any success stories. Now, Glenn is one of the few people. I've only met Glenn. I think we've met maybe 2-3 times at the most. It'd be probably 15 years since we met face to face. 10 years anyway, maybe more than that. But I've always had the feeling that you might be one of the people who would really figure this out. Have you had any success with your particular strategy in the land patents?
Absolutely. I have met people who have never been on the tax rolls. They pass their land on from generation to generation in their family with basically a father gives a quitclaim deed to their son and then tell them to go take that quarter over there in the northwest quarter or something like that. And they've never been on the tax rolls, and they have the original land patent was granted to their family. I've met people, and they've showed me that stuff. And,
all right. Now, and the question is, though, I mean, I understand that if someone has maintained a land patent and it's gone from father to son to grandson, for example, through a series of generations of a family, the land patent was granted to grandpa. He gives it to dad. Dad gives it to grandson. I can understand that, but what about someone who is just now beginning to understand a little about land patents? They do a little bit of research and they find out, oh my gosh, there's a land patent back there with my grandfather's name on it. Can he make a claim on that land patent if it has been essentially abandoned for a period of time? Can the heir still make a claim on that land patent? Is there an effective strategy for doing so? Or is this something where you've got to, you got to take it from dad who got it from grandpa and so on?
Actually, the only reason I explained that is that the principle is extremely valid. And yes, I mean, if you read the land patents and you watch my videos, I actually have a bunch of land patents on my videos. And if you read them, it says that this land is granted to Joe Blow, his heirs, and or signs forever.
Yep.
Okay? And so, yes, you can. And I've done it, actually. Some states, it depends on the corruption of the bureaucrats and things like that. Some states, it's easier than others. But I have definitely done it. I own several parcels of land. I own 2 parcels out in West Texas, a 10-acre parcel, a 20-acre parcel. I own several parcels in Arizona. And one of them, I had to take him to the U.S. Court of Appeals for the Ninth Circuit. And it's kind of interesting to notice that they ruled against me, but they also, at the same time, they went silent about the taxes.
They ruled against you, saying that you didn't own the land patent. You weren't the heir to the land patent for the land, but you still held the land without the land patent. Is that what we're kind of saying there?
No,
you didn't have to pay taxes.
The issue was over property taxes, and they basically said, like they always say, anytime they dismiss it for it's a 12b-6, which is failing to state a claim. Right. And so, but at the same time, they went silent, okay? And so they essentially agreed with me because they don't have authority to even talk to me, because that's what 12b-6 is basically saying. And the problem went away. And that was the Ninth Circuit. Now, usually I can handle it administratively. Like Arizona is particularly one of the better states, in my opinion, because a lot of states have a statute that says that they, in order to do a land transfer, you have to do an affidavit of property value. Some states have a land transfer tax, and those are perfect if you think about it, because what you do is there's court cases that say that once they've got the document, once the recorder has the document, it doesn't matter if they file stamp it or not, it's filed. And so you serve it on them. What I do is I prepare my document, I serve it on them by registered mail, and then they send it back with a little unsigned letter saying that you forgot to pay the land transfer tax, or in Arizona's case, you forgot to include the affidavit of property value, and then it says, we've put it in a special file until you return this affidavit of property value. Well, that's perfect. That's the non-tax-paying file.
So isn't that special then, huh? If you don't have to pay taxes. How many people have been attracted to your videos and to your strategy, and how many people do you think have succeeded?
Well, I don't know how many have been successful. I know I've helped a few people. When I've got 7,000 subscribers on my YouTube channel right now, I have, because YouTube and Google are on a hate for anybody that doesn't trumpet the party line. I've recently opened up a VidMe channel and a profile on Steemit, and so I'm starting to spread it around a little bit more, which is actually creating a lot more interest too. So the end result is that I have helped people. And what you have to do is we all have to pick our battles. And so my attitude is I'm not paying them property tax, and I'll drag their butt into court if I have to. And that's why I wound up in the Ninth Circuit. But usually I try and handle it in a way that doesn't wind up in the courts. And if that works, then that's great. But if not, then we go to the Ninth Circuit. Actually, I would have gone to the Supreme Court, except that I did a petition for writ of error. And that's a long story about why I did a petition for writ of error. But if anybody knows anything about the Supreme Court rules, it has to be a certiorari. And so, the clerk sent it back, and then I didn't get it changed to a certiorari in time, because I actually had 2 cases that were going to the Supreme Court at the same time, and there was another one that I wound up taking to the Supreme Court instead. But so they still went silent. That's the bottom line. And I should have taken it to the Supreme Court, quite frankly. But I think the Supreme Court is the only real court in the country. At any rate, yeah.
I've got a quote here from someone else. This is research someone else did. I'm assuming this is valid. I have no doubt. I really believe this is a valid quote, but again, I haven't verified it myself. Case of Wilcox versus Jackson, 13 Pett, which is United States, early court clerk for the Supreme Court, 498, 10 lawyers, edition 264, and it says the land patent is the only form of perfect title to land available in the United States. Do you agree that the land patent creates perfect title to land?
Well, in the United States, it's the highest and best title, but actually there's also court cases that say that the land patents are a quitclaim deed. And if you think about it, because really the government stole the land from the First Nations people. And so that's what I've actually done, and I did it in Canada in particular. But I would like to do here is get some First Nations lands grants on some BLM property and then get up in their face and tell them if they want to talk about it, we can talk about it in court and see what they do. You know what I mean?
I do, but why don't you explain to people who are listening what you mean by a quitclaim deed?
Well, a quitclaim deed is, I'm sure you've heard about the Brooklyn Bridge being sold.
Multiple times.
Right.
It's like gold. It's like gold on comics. You can sell that several hundred, sell the same ounce of gold several hundred times. Nobody ever takes delivery.
Yeah, you got that right. And so what happens is all sorts of people, what a quitclaim deed is it says, and actually in Texas, all tax sales are with a quitclaim deed. Anyways, a quitclaim deed is basically saying I sell my interest in this property. I may not have an interest, but whatever interest I have, I sell. And so when the tax thieves do sell the property they've stolen, they really don't own anything. And anybody that knows the law would be able to defeat that in a heartbeat, and there's court cases that actually talk about it. But so the bottom line is that's all a quitclaim deed does, sells whatever interest you have in the property.
We've got another quote here from McCoy versus Lowry, 42 Washington 2nd, 24, and it says the warranty deed is merely a color of title. Color of title means that which is a semblance or appearance of title, but not title in fact or in law. And what they're telling us is that here's another one from Weinman versus Gastrell, 54 Fed 819, and it says the warranty deed cannot stand against the land patent. A grant of land patent, is a public law standing on the statute books of the state and is notice to every subsequent purchaser under any conflicting sales made afterward. Were you able to follow what I read there, especially the second? Well, first off, the warranty deed doesn't stand up against the land patent. Land patent would appear to be trump. If you can produce adequate evidence that you are heir to the land patent or you are the legitimate holder of the land patent, that means you get the land. Is that true or false?
It means you have absolute title. You're literally king on that land. There's three things that are required to be truly sovereign. You have to have people, you have to have land, and you have to have resources. So it was originally conceived, in my opinion, under the Constitution that all the people were intended to be sovereign. And if you read the Land Act of like 1820, it talks about how they wanted unembarrassed freeholders to own the land. And if you don't have land, then you can claim to be sovereign, but it's if it comes up, it's a problem. You see what I'm saying?
I think I do. What you're saying is that you can't be sovereign without land.
Absolutely, you got to have land. That's why the first I've got this site from it's from a law dictionary back in the 1835. It's I can find it real quick. Anyways, no, it's kind of an unusual one. Let me see, just a second.
And don't forget to subscribe to this YouTube channel. And don't forget to follow me on VidMe. And the link to my VidMe channel is right there at VidMe, at Sovereignty International at VidMe. VidMe.com, actually. But anyway, so don't forget to follow me on Steemit at Sovereignty International. And if you follow me on Steemit, let me know and I'll follow you. Don't forget to like this video. Don't forget on YouTube, don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On VidMe, don't forget to upvote this video. And on Steemit, don't forget to vote and make your comments. This is my YouTube channel, and you notice the arrow's pointing at the bell. You click on the bell, a little window will pop up, and you got to check a box that says OK, and click OK so that you're notified of new uploads. This is Steemit, and you see where the first arrow on the left is pointing at this up arrow. That's where you can upvote. The middle arrow tells you how many have voted, and the right arrow is where you can add in comments. And so I'm putting up postings. Basically, it's a blurb on a video, and I attach the video, and so then you can watch the video on YouTube. But all that's on Steemit, and you can make comments, and they like comments on Steemit. This is also on Steemit. This is actually another user called Crypto Wallet. And if you notice my mouse, the little hand there on my mouse is over touching the Crypto Wallet, and this menu, this little pop-up, this little menu comes up, and that's where you can unfollow or follow someone, and that's how it works on Steemit.
It's Tomlin's Law Dictionary under the definition of mort main. In Volume 2, you want me to read it here? This is like really, it says, quote, "Yet still it was found difficult to set bounds to ecclesiastical ingenuity," okay, as in the Roman cult. "For when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted, not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief."
What do they mean by the season of the land?
The possession.
Okay.
While the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, as in the Roman cult, to be bound in conscience to account to his sesticate use for the rents and emoluments of the estate. So, and let me finish this real quick, and I'll tell you what it means. "And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts for the foundation of modern conveyancing," unquote. So if you think about this, what they're saying is that the Roman cult created this sesticate trust. They put the land under the name of the sesticate trust, and then the courts of equity that were under the control of the Roman cult said, well, since you're going to put this in the name of the land under the sesticate trust, and yet you're going to use it, then you got to account for the rents and emoluments of the estate. That's property taxes. It all comes together right there in that one statement. And that's in Tomlin's Law Dictionary, 1835 edition, Volume 2, under the definition of mort main.
Well, what I understand about trusts is that in order to create a legitimate trust, you must first have, the grantor must have perfect title, meaning he has both equitable title and legal title to whatever the property is that's going to be placed into the trust. If he holds both legal title and equitable title, he has perfect title. And if he does, he can take that perfect title and divide it into the trust and give legal title to the fiduciary or trustee and give equitable title to the beneficiary. And this division of title creates a certain amount of defensive advantages, but what you're also suggesting is that it creates a certain amount of liabilities because you no longer own your land in terms of perfect title. If I own land but I don't hold perfect title to it, meaning to my mind both legal and equitable, do you think I can still stand up and claim to be a sovereign without having some kind of land, either legal title or equitable, but not both? Do I have to have perfect title in order to claim to be a sovereign?
If you truly want to do that, to claim sovereignty, then that's what you have to have. But as with anything, like in any court case, the judge is sitting there playing stupid, and the issues, he rules based on the issues that are presented to him. So if the issues of the land don't come up, then you might get away with it. But if you want to be truly a sovereign, you have to have land, resources, gold or silver coin, and obviously you already have people, but you got to have all three.
All right. I've got another quote down here. Let's see if I can find it. I'm scrolling. It says the land patent is permanent and cannot be changed by the government after its issuance. That's a summary. This is derived from Cage versus Danks, 13, L.A., Louisiana, assume, and 128. It says where the United States has parted with title by a patent legally issued, and upon surveys made by itself and approved by the proper department, the title so granted cannot be impaired by any subsequent survey made by the government for its own purposes.
Yeah.
What if a survey is made by some private entity? It says the government can't make a survey. Can a private entity make a survey that could be a basis for a kind of fraud, where the survey is made in a way that says, this land is no longer under the land title, it's off here under maybe lot and block.
Well, and that's see what they did. Think about it. When they went back in the 1800s, they had all these railroads that were being built, and they granted 10 miles of land on either side of the railroad to finance the railroad. And so then what they essentially did is they granted a perfect consummate title to the railroad company, which is a fictitious entity and owes a duty by definition to the government. And then when the railroad company sold it, they sold a colorable title. And if you didn't understand what you were buying, you could bring forward all the rights and privileges of the land patent, but most people didn't have a clue about it. And so they basically got turned into tenants by doing that.
I understand that, and when they got turned into tenants, they certainly abandoned, they unwittingly waived their status as sovereigns. Is that true?
Well, I mean, there's no such thing as an incompetent sovereign, so if they don't know they're sovereign, then they're not.
All right. And from my perspective, the way I look at the issue of sovereignty, I find it flowing from the Declaration of Independence, which says we hold these truths to be self-evident that all men are created equal and endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That endowment by God, I believe, is the foundation for individual sovereignty. And when they say all men are created equal, I think they mean including King George, for example. If he was sovereign because he got his rights from God in a coronation ceremony that was performed in a church, He didn't get his rights from an election. It wasn't from an appointment in the ordinary sense of the word. It wasn't an administrative appointment. This was a situation where the rights flowed from God. He had the divine right of kings, and I think that's what they did in the Declaration of Independence. They essentially said we all get our rights from God, or at least our most important rights flow from God, our Creator. And with that, we all enjoyed the same divine rights as King George, is the way I look at it. I'm inclined to look at it. Where was I going with this, Frank?
I'm not sure.
You don't know where you're not. All right. Well, I lost my point.
I agree. And under the original Constitution, that is 100% correct. But in Downs versus Bidwell, the Supreme Court actually said that there's two national governments, one that operates within the limitations of the Constitution and one that's operated by Congress.
Yes,
and,
I agree.
and
Article
really,
4, Section 3, Clause 2. Congress has exclusive legislative jurisdiction over all of the territories and states of the United States, which is not the same thing as the states of the Union. States of the United States of America are not the states of the United States. Two different entities. The one is under the second, I mentioned, states of the United States, under Article 4, Section 3, Clause 2 of the Constitution. The first one, the states of the Union, they're the ones where government has only limited powers under Article 1 of the Constitution. They have limited powers there. Under the alternative states, they have unlimited powers, and this includes the land. If they have unlimited powers, how do we hang on to the land? I mean, I think I've heard that you've said that you want to stay away from the zip code, for example, if you want to make a claim on land under a land patent. Is that true?
Well, absolutely, yeah. Zip code's a federal. That's 10 square miles over there between Virginia and Maryland.
Mm-hmm. Mm-hmm. I think it's also evidence of a state of the United States as opposed to a state of the Union. I don't think there's a zip code in the states of the Union. And I think if they can persuade you to use the zip code, it becomes evidence you are in that plane where Congress has unlimited jurisdiction. They can do anything they want within the territories and or administrative districts and or states of the United States.
Yeah,
so,
the courts have ruled.
Go ahead. Huh?
Well, the courts have ruled numerous times, quite frankly, that if you're a U.S. citizen, then you're not entitled to an Article 3 court. You get an Article 1 court. And the boundaries of the District of Columbia expand as necessary throughout the states of the Union to deal with U.S. citizens. So it all comes down to the citizenship, to this de facto corporation, and since all the courts are these Roman cult Baal priests, they just automatically presume it until you defeat their presumptions.
I agree with that. I basically agree with that. One of the things I understand a little bit about admiralty, somebody's got to have legal title to the ship. If you're dealing with a ship and there's a debate over who owns it, it starts with the legal title, not the equitable title, but the legal title. And if somebody brings that in, okay, we can go to a court of equity. I suspect, you mentioned earlier you were talking about a 12b6 motion for failure to state a claim for which relief can be granted. And they've used that against you in at least some instances. Is that true?
Yeah, I would say in just about every one of them.
Do you think 12b6 only applies in courts of equity? It says it's a failure to state a claim for which relief can be granted. I'm inclined to view the word relief as evidence that we are now in a court of equity. Relief to me is something that you get in equity. I don't think you get in law.
I agree. Yeah, you're 100% right.
And therefore, I think the 12b6 motion is taking as evidence that they are proceeding in equity. If you bring up the land title, however, and you are making that claim, I don't think they can proceed in equity, at least not lawfully, because legal title is one of the two that are combined in that land patent. They've got legal title and equitable title equals perfect title in the land patent. I think they have to take you to a court of law, but my question is, do they have courts of law anymore?
Well, quite frankly, I don't believe they do, except unless you're with the Supreme Court, because all the lower courts are basically territorial. I believe that they can operate lawfully, but they don't, because they collect royalties. There's a whole bunch of reasons why they basically fabricate evidence of their slave so that they can collect their royalty and make a bunch of money.
Well, that's they tell you that they're dealing with their customers. I mean, they'll refer to us as customers in a lot of government agencies, and perhaps even the courts. And that's pretty good evidence. At least it raises the implication these people are in it for the money. They're not in it to dispense justice. Go ahead. My last Supreme Court case, I went and it was over filing fees, and I proved that the filing fees came from an appropriations bill when Puerto Rico became a territory. That's where the filing fees came. But prior to that appropriations bill, they were all called the District Court of the United States. Okay, yep. All the federal courts. Now, after that, they're now called United States District Courts, and it started in that appropriations bill for Puerto Rico. Well, there's court cases that say that they cannot, number one, they cannot put legislation in an appropriations bill. Number two, that in the original 1871 Act to incorporate the District of Columbia, says in there that they cannot. They have to have all of the summary of the bill has to be in the title, and if it's not in the title, then it's not valid. And so there's two reasons, and there's even Supreme Court cases that talk about it, how they cannot put legislation in appropriations bills. Well, let me ask you this. When they say you can't put legislation in appropriations bill, okay, are they saying, is that the law that applies within the states of the Union, or is that the law that applies where Congress has exclusive legislative jurisdiction, territories, administrative districts, states of the United States, or does it apply to all of them? What I'm trying to get to is there are two different planes. There's one where Congress has limited jurisdiction under Article 1 of the Constitution. There's another one where they have unlimited jurisdiction under Article 4, Section 3, Clause 2. Does the rule that you can't put legislation in an appropriations bill, does that apply in both places, in both planes, or does it only apply in one?
Well, because it's an appropriations bill, it would only apply in the District of Columbia and the territories. But having said that, I don't believe that they've done anything, that Congress has done anything after 1861 that was... Everything they've done is for District of Columbia and the territories. So the entire D.C. Code is for District of Columbia, I should say United States Code is for the District of Columbia and the territories. Not entirely. Actually, there's some sections where they actually very well, like in the Transportation Code, they define, when it talks about roads and things like that, they define all the states. Whereas most of it, though, I'd say about 99% of it is just for D.C. and the territories.
I agree that they are passing, and it's part of what I think happens in the courts, what I suspect. There are two ways to attack a particular law as unconstitutional. You can attack it as facially unconstitutional, which means it's unconstitutional. Every time you ever try to apply it on its face, it's unconstitutional. Or you can attack this law as unconstitutional as applied in your particular case. My understanding is the court is far more inclined to rule in your favor if you're only alleging that the case is unconstitutional, that the law is unconstitutional in your particular case, but they will almost never grant the idea that the law is facially unconstitutional. And I think the reason for this is because you pass a law I think the way I suspect, and I don't know it to be true, so I'm interested to hear whether you agree, disagree, but they pass a law. And if they don't specifically say which plane it applies to, then wherever you are, you just, well, of course, the law applies where I am. But maybe the law is absolutely constitutional under Article 4, Section 3, Clause 2, but it's not constitutional under Article 1 where they have limited powers. Do you see what I'm saying? And the point being, as long as they can always say, well, it would be liberal, it would be legal within the territories, Washington, D.C., administrative districts, states of the United States, it could be legal there, and therefore we're not going to find it facially unconstitutional. Do you follow what I'm saying there?
I follow you 100%, and I think that you're 100% right, but I also think that that all the legislation they're doing is for D.C. and the territories.
I understand.
Announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently $1.99 because it avoids the advertising only. But you can, if you like my work, it can be a donation. The only reason it avoids the advertising is because my agenda is to expose these New World Order Satanists and the fraud, because their only power over us is through fraud and deception. And my agenda is to expose it for all our benefit. And so that's for that reason. There's not going to be much exclusive content on that channel. There is some, and we're going to go through some of it here in a minute. But there's not going to be as much as, you know, if I really wanted to make a lot of money off the thing and wasn't concerned about notifying people, then I would do it that way, or I would have it all exclusive. Anyways, I'm currently publishing 3 videos a week on the subscription channel and 2 videos a week on the free channel. Some people have had trouble finding the channel. A link to the channel is at the bottom. And some of the stuff that's on the channel is that's exclusive is Arlington Private Information Chair, my land deed training, my estoppel certificates training, foreclosure estoppel certificates training, corporate denial training, toll road notice and demand training, invoice training, notice of void judgment training, revocation of signature training, and third-party witness training are all on there, and they're all exclusive to that channel. Some upcoming exclusive content is lawsuit training, criminal complaint training, and other training, depending on what people request. I'm open to ideas. This is the front page of my subscription channel, and if you notice, the top arrow is pointing at the address, the URL. So if you have trouble finding it, you can just manually type that in. The bottom arrow is pointing at the Start Free Trial button, and the reason is because some people actually sent me a $1.99 donation, and I wasn't sure what that was for. I was thinking that they wanted me to subscribe them to the channel, and I have absolutely no control over subscribers. I can't even see all the subscribers. So if you want to subscribe to the channel, you'll have to click on the Start Free Trial button. I imagine YouTube is going to want to get payment information or something from you in order to go through with the process. But that's the only way that it can happen. So, you know, I wound up sending those people an email and offered to refund their $1.99, although they didn't respond, so I guess that means it was a gift. But anyway, so the bottom line is that if you want to subscribe, you know, that's how you have to do it.
I understand, but the average person sits out here and we think we're operating within the states of the Union, and I think they think we're operating within some administrative district or territory of the United States. And we argue that you can't do that to us because you only have limited powers, and that's what it says in Article 1 of the Constitution, limited powers, and the government says, sonny, they don't even say it, but they assume that we are in the territory where they have unlimited powers.
Well,
therefore, our arguments fail because we're arguing baseball and they're playing football.
what they do is they do all these little tricks to create their presumptions that you're one of their slaves.
Yeah.
And filing fees is a perfect example. Federal Reserve notes under the Gold Reserve Act of 1934, Federal Reserve notes are meant for internal use of the government only. And so there's anybody that uses Federal Reserve notes is basically saying that they're a government employee. And so they won't let you proceed unless you pay their extortion, or you fill out this impecuniosity form that's only for U.S. citizens. And actually, this was an issue that I brought up in my recent Supreme Court case, was that it's only for U.S. citizens, but it's only for attorneys also, or in naturalization proceedings. This is the only times the filing fees are applicable, or not the filing fees. Well, actually, the filing fees and the impecuniosity form that they make you fill out.
I've never heard of an impecuniosity form before. What does it actually? I don't know what impecuniosity. I mean, it has something to do with the money, but what does it mean? This isn't like a form on paupers, is it?
Well, I don't pay filing fees. Let me put it that way. And
okay,
so
but I'm curious if you know what impecuniosity, what does that word mean, and what are they looking for on this form? That's
for paupers, exactly.
Okay, then it is. That's exactly that. Yeah, that's what I thought it sounded like. In form of paupers.
It's for paupers, and if you're a pauper, you don't have any rights, even at common law.
I understand that. It would make you a ward of the court, essentially, I suppose. Do you think that's right or wrong?
Well, yeah, exactly. And so, I mean, that's the worst place to be. You're an imbecile.
Yeah, I understand. And you're in a court of equity where the judge, or I assume you're in a court of equity, where the judge can do anything he wants as long as it matches up with his alleged conscience. If it feels good, do it. That's why the courts rule in equity, generally speaking. That's kind of an exaggeration. But they're not bound by the law in courts of equity. They can listen to it. They can be influenced by it. They can be persuaded by it. But they're not bound by it. They can do anything they want. And that's why they're so dangerous. If they don't like the color of your eyes in equity, they can rule against you. And the Supreme Court will say they're acting in their, they have jurisdiction. They're in their discretion. They're acting within the limits of their discretion.
But it's more than that, because when the government goes bankrupt, common law disappears, and all there is equity. And that's why they have to pass statutes for common law crimes.
No, I understand exactly what you're saying, and I'm sure you're aware that at one point, and I don't remember the year precisely, but it might be 1948, it might be later into the 1960s, I don't recall when, that they divide. Prior to that, you had courts of law and courts of equity. And the law had its own procedures, and let me see, there were procedures and one other thing that were there, and this was the same thing. Equity had its own procedures and its own laws, its own rules and regulations. And what I'm getting to is it was almost, if you were suing someone in equity, it was almost different procedures and different forms. That's what it was. They had two different sets of procedures, two different sets of forms. If you were being sued in equity, you could tell it was almost as if a lawsuit in equity had to be on red paper and a lawsuit at law had to be on green paper. Now, that's not true, but they each had distinctly different procedures and distinctly different forms. So you knew this law is at equity. And then they combined the law, they combined the procedures, and they combined the procedures and forms. They combined them both where they were identical at law, they're identical in equity. And the average person now thinks they're going into a court of law. They can't tell anymore, and nobody's going to alert them to the fact. I think they're always going in, or almost always going into a court of equity. Does your experience match up with that at all? Is that something you've seen, observed, sensed, or is it do you disagree?
No, I agree 100%. I think it's calculated. It's these bar members that are all foreign agents of the Roman cult that have done that to be deceptive. It's all part of their money-making scam. And And because you're right, I mean, there was a libel is something that goes on in an admiralty suit, in an admiralty proceeding. I mean, the different forms of action were all clearly different, and what they did is they come out with one form of action. It talks about it in the first in Rule 1. Yeah,
that's right. That's right. And again, I don't recall clearly, but it's in the 20th century, 1900s. 1948, maybe 1960 something. I don't recall clearly, but they have combined them both together, and I've seen it. I've seen reference to it in the beginning of Rules of Civil Procedure. I think it was the Federal Rules of Civil Procedures where I first caught wind of this, and it'd be 20 years ago. I'm not sure if they still talk about it, but if the point being, one of the most important points is that, from my perspective, all rights flow from title. Fundamental principle. And that means if you want to get into a court of law, you must start with a legal title. If you have an equitable title, if that's all that's implicated in the case, you're going to a court of equity. If you want law, somebody's got to claim legal title. Whether you got it or not, you got to claim it, or at least that becomes the issue that has to be decided, and then the court, in theory, has to act at law, but I'm not sure that the current courts can. And it may be more complex than what I'm suggesting here. For example, what do you think is the consequence? You don't pay filing fees, right?
Correct.
What do you think is the consequence of paying filing fees denominated in legal tender?
Well, again, it goes to the Gold Reserve Act of 1934. You're basically saying that you're one of the slaves.
I think you're right. I think that the danger may be that when you go in and you file lawsuits, I'm going to sue this SOB. All right, go ahead and sue them. And when you walk in the door and they say, well, the filing fee will be $300. Okay, here's $300 bills. What have you just told them? I think you've told them we're going to hear the case in equity. I think you told them you're hearing the case in equity because you did not put up tender. You didn't put up gold and silver. So if you only got this legal tender, fine, we'll hear the case, but we're going to hear it in equity. And I think you're kissing your rights goodbye when you use those Federal Reserve notes.
Well, now the thing is, though, like any other presumption they make, it's rebuttable. Now, if I go in there and say, look, I want to have a court case, and they go, okay, fine, you got to pay the filing fee. And I go, all right, well, what is it? Well, it's this much. Okay, I'm just letting you know I'm paying this under duress with these Federal Reserve notes. It's not to mean anything except necessity because you have taken lawful money out of circulation. There isn't any, so out of necessity I'm doing this. It's not to mean anything. It's at arm's length with all rights reserved. Now what?
I agree with you. I think if you can tell them I will pay with these Federal Reserve notes provided that they create an illegal disability for me.
Well, yeah, because it is what I say it is until you can prove it ain't.
Well, once you say I'm not going to accept any legal disability, and they either have to tell you, oh, yes, you are, you have to take the legal disability, and I don't think they can say that in public. I don't think they can say that on the record. So once you raise the issue, it's kind of like bluffing at poker. I don't think they can deny what you've said and say, oh, yeah, you're taking, anybody uses Federal Reserve notes suffers a disability.
Yes, and we're happy to say that in open court.
Yeah, right. No, they won't say that. I think they have to let you go. But you do have to say something. If you don't say anything, I think and this is part of the reason I've suspected. I have no evidence to prove it. It's just suspicion. But pay that filing fee in Federal Reserve notes, and I think you are condemning yourself. You're walking into a courtroom where you really don't have any power or any rights worth mentioning.
Well, it's just like all the, we've done entire shows on just presumptions, but I mean, the courts are loaded with them. I mean, you can go to your state court's rules, and here in Oregon they have 4 pages of just, okay, here's the presumptions. When you walk in, this is what we're presuming. And they don't tell you that when you walk in because, hey, it's in the law, you're supposed to know.
What about our presumptions? You know, how many presumptions do ordinary people act under? For example, we presume that Congress has limited powers in the states under Article 1 of the Constitution. We presume that we're in states of the Union. What if we drafted a document that listed our presumptions? Would they deny them?
Well, they'd have. I think they have to, because
I know they would.
The rules say a presumption stands until rebutted. So if we make, those rules apply both ways. So if I make presumptions, it's just like if I go, into court and say, okay, look, here's the facts. This is a fact, this is a fact, this is a fact, this is a fact, this is a fact. Well, okay. Now, I don't know, technically, maybe I have to do an affidavit. Maybe I just need to list the facts in my court documents. I don't know. But, the facts now stand as facts until somebody says, oh, no, that's not true.
Glenn, when you start when you are trying to apply a land patent, do you try to establish your claim on the land patent with an affidavit? Or do you try to establish your claim on the land patent with a declaration that claims you are you're the legitimate holder of the land patent?
What I do is I transfer the land. I manage some limited liability companies and some trusts and things like that. So when I'm planning on bringing forward the land patent, I have them deed the land, because most people that are selling it don't have a clue about wording on deeds. Some of them even have liars that are giving them to. And so rather than create a big controversy about how I want this thing worded, I just let them go ahead and word it however they want. And I have them, put it under Texas American Holdings or something. You see what I'm saying?
Not exactly.
And so then...
it's my, superficial understanding that if you're going to claim that land patent, I think you have to claim it in the capacity of a living man. And if I'm understanding what you're saying, you are allowing the land patent to be moved into these artificial entities, or you just the land, or I don't understand exactly what you're saying there.
Yeah, I wasn't finished.
Okay. Frank, don't interrupt.
Anyway.
Stop interrupting, Frank.
Anyways, now wait a minute. I'm not acting in the capacity of a producer. You can't blame me.
Mm-hmm. Well, that's your job. Is you take responsibility for all these things, Frank. You know that. Producers are responsible. It's kind of like being a U.S. citizen. It's a step below being a U.S. citizen. U.S. citizens are responsible for everything. They don't have any rights. Producers, radio talk show producers, they are even a step below U.S. citizens.
Thank you.
You're welcome. Go ahead, Glenn.
So, anyways, what I do is I have them transfer it, or I buy it. Also, another thing is,
you buy what? You buy the land. You're not buying the land patent. You're buying the land.
No. Yes, and there's wording that I want on there. In other words, in order to have absolute title, you have to use gold or silver coin, number one. That's probably the biggest, most important thing, is to use gold or silver coin. You cannot use Federal Reserve notes because, that by definition creates a trust. And so you cannot use Federal Reserve notes. And so I don't want to. I pay the Federal Reserve notes, and they deed it under a trust or a limited liability company or something like that, and then I transfer it from the trust or limited liability company to me, and that's when I put in all the wording that I want, and I pay for it with gold or silver coin, and I bring forward all the rights and privileges of the original land patent, and I define who I am, as in a man, not a 'K trust, not a U.S. citizen, that kind of thing.
I understand. But you are telling us, if I understand correctly, that you are not the blood heir to the land patent in question.
No, that's right. I'm an assigned.
Okay, you're an
All
assigned.
the land patents talk about assigns. All of them talk about assigns, so I'm an assigned.
Okay, can you tell us more about the definition of a sign? For example, where I'm going with this, can I be then a sign if I purchase land with Federal Reserve notes? Or to be an assigned, you have to have gold or silver to buy the land?
Well, everybody really is a sign, but what happens is if you pay for it with and I have actually, I mean, I've done it with defects when I was first doing it. Matter of fact, when I first started this, you remember you said that about 10 years ago is when I really got going in this, and that's true.
I'm just guessing.
Because, well, and so, but what happened about 10 years ago is I decided to pay off my mortgage with a promissory note. And of course the bankster thieves stole my property, but meanwhile, I brought forward all the rights and privileges of the land patent. I encumbered that property big time with common law liens and all sorts of stuff. And so the guy that bought it can't sell it. He's got to rent it out. And technically, I mean, at some point, I'll get some justice and I'll probably be able to go get it back. But so the point being is that you bring forward. I've heard people talking, even title companies. I've talked to title companies, and they will say, where I'd be showing them my paperwork, and they'd say, if you do that, you'll never be able to get title insurance. And if you think about it, that's perfect.
Yeah,
because with an insurance company,
they make it sound like a bad thing, but I'm not sure that it is.
Well,
I think that
not,
insurance only exists in these territories, administrative districts, and states of the United States. I'm not sure there is title insurance, and maybe not any kind of insurance within the states of the Union. And that's a stretch. That might not be true, but it's a suspicion.
No, there's not, because an insurance company, they have teams of lawyers. They have to have an insurable thing, and for them to insure a land patent would be a fraud because it doesn't need insurance.
Yeah.
And so that would be an open fraud. That would be breaching their corporate charter. So that's why they'll say you can never get title insurance because it doesn't need to be insured. I mean, it's like you get life insurance. And you get a life insurance on your mother or your daughter or your kids. But I can't get life insurance on the neighbor because I don't have an insurable interest. And it's because if I did, it'd be a fraud. And it's the same thing with trying to get title insurance on your land. For them to issue an insurance policy on something like that would be a fraud. The land is unassailable. Sure. And in fact, a good example was a friend of mine in Texas. I went and helped him bring forward his land patent, and he was fighting with the property tax thieves. And this was in Azle, a town, Azle, which is, you know where Azle is?
No, I've heard of it, but I don't know where it is.
It's west of Fort Worth, about 15 miles. Anyways, on 199. Anyways, so what happened was I helped him bring forward the land patent on it, and then he died. And his wife and kids were dealing with the tax thieves, and they didn't have a clue, and they didn't even care. And so the tax thieves basically stole the land and sold it, and the neighbor wound up buying the land. The neighbor was the mayor of Azle. And,
what a coincidence.
And a friend of, yeah, right. How convenient, eh? Anyways, so a friend of mine knew the mayor, and he was talking to him one day. And this mayor told him, he said, that land patent really screwed up that land because he couldn't get a mortgage on it. Well, think about it. It's the same thing that what will happen is the banks won't loan you money on it because there's court cases that say that no equitable title can trump a land patent. Yep. And so what happened was he had to get a friend to loan him like $150,000 to buy this land.
CubeYard.com. For great custom websites, domain names, and hosting, go to CubeYard.com. Use coupon code CY172 for 20% off your first order. CubeYard.com, your source for websites, domain names, and hosting.
Well, a friend of mine and I were watching some documentaries put out by the State Bar of Texas on land patents. And one of the attorneys talking, well, it wasn't on land patents, it was a subject that came up in the course. It was about title to property, particularly oil property, or oil-producing property, and one of the attorneys specifically said, I'm giving a rough quote on this, it's not exact, but if any of the heirs show up with the land patent, it's a real buzzkill. And that was his language. It was a buzzkill. And the system that we have today probably is not compatible with the land patent. And if someone shows up with the land patent, and the law is as strong as it appears to be, that it trumps anything else, that if there's anything else out there, land patent trumps it. If you can show up with that land patent, it's going to buzzkill for anybody else who wants to claim that land. You get it. It's Trump. It's
yes.
Like, yeah. I've got another quote here. This is again supplied by a friend of mine. It says, land cannot be taken for debt or taxes, but real estate can be taken. It goes on and says, what is real estate? It's a document that lays over the land in color of title. It is proper only when no real title to the land exists. Banks and corporations like real estate because they can own it without an act of Congress. They and the others can use the fiction of title to seize land under the color of law. These things are always hard for people to listen to and understand. I understand that, but they're telling us that land is not real estate. And the quote is at least implying that land is the subject of land patents and real estate is something else entirely. Is that your experience?
Yeah, think about it. Estate is the operative word. Estate is something you have an interest in, but you don't own, like your father's estate. You have an interest in it, but you don't own it. That's the Sesticate Trust, is just another type of an estate. And so you have an interest in it, but you don't own it. People have tried to get their birth certificate, the original, and the government says it's not yours. You can't have it.
Well, it's like, dead people can have an estate. Dead people can't really own land.
Well, they can own...
No, once you're dead, you're dead. You don't own anything.
Land, about 7-8 foot long and maybe 3-4 foot wide.
But when you go to probate court, they're talking entirely all the time about the dead person's estate.
Yeah.
They're not ever saying,
the
land, the this, the that. No. It's the dead person's estate. So it's not, in my mind, it's a fiction. It's not a real thing as an estate.
You're right.
I'm inclined to think of the estate as a trust. And there's some res in the trust. There's property in the trust. You may have an equitable claim on that property. The court is probably sitting in the capacity of a trustee to administer that estate on behalf of the beneficiaries and divide it up among whoever is in there. That's the way I'm inclined. I don't know if it's true or false. Frank, does that seem true to you? Len, does it seem true to you?
I had to do this with my mother. Okay, she died and she had some stuff, but there was no will. So I had to file to become the administrator of the estate. Now that sounds an awful lot like, the trustee of a trust.
That's what I would guess.
It sounds very similar, and the way you go about it is very similar. I mean, it's different words, but that's kind of how it operates. And you just
let me ask you this: if you were the administrator of that estate, and if we're correct, and the estate is a trust, and there's property in that trust to be divided did you get any of the property of that trust, or did it go to other beneficiaries?
Well, under that, there's just like a trust, there's rules, okay? Who are the beneficiaries? Well, when somebody dies, the beneficiaries are the next of kin. And whoever's the next of kin can make a claim. And the administrator, and if there's a will, you're called the executor. But if there's no will, you're called the administrator. And the thing is, somebody comes with a claim and says, hey, I'm a second cousin of a first uncle, and, I want some of this stuff. The administrator has to make a determination based on whatever's been provided and then says yes or no. No, you get nothing. Yes, you get something. Yes, you get everything. And if there's a dispute, that's when the judge has to say, okay, let me decide here. What's why'd you deny this claim? And the administrator gives the evidence. The heir gives their evidence about why they think they ought to have it, and the judge decides. That's how it works in probate, anyway, with a death estate.
But can you, as administrator, receive any of the benefits, any of the res that's in that estate?
Well, not. You can be a beneficiary, okay? Like in my case, I was the only heir, and I was the administrator. Now, You don't get anything, okay? All the costs, whatever happens that, because there are costs involved in administrating an estate, burials and all these things have to be paid for, and there has to be money. And if you don't have it, then it has to come out of the state. And all those funds have to be accounted for. They're not yours to just do whatever you please with. The administrator also has a statutory payment that you can, like a salary, that you can be paid for doing the administration of the estate. But, yeah, you can also be the heir or beneficiary. But that has to stand on a whole separate thing. You can be both the
administrator and the beneficiary. Is that what you're telling me?
Yep.
Now, that surprises me because my understanding of trust law, and I'm assuming this estate falls into that classification, my understanding is that the fiduciary cannot be a beneficiary.
Well,
and the beneficiary can't be a fiduciary. If you combine those two in the same person, I think you have both legal and equitable title in the same person. You have perfect title, in my opinion. Well, the trust is collapsed, and the administrator gets the whatever was the res in the trust.
Well, I don't think
perfect title.
I don't think estate law is like pure trust law. Mm-hmm. There's some variations because that is true that you can be the administrator and the beneficiary. I was. So I know that works, and it's. It's like anything else you get into, when it starts happening to you, you got to deal with it. It's like time to hit the books and learn everything you can learn about, estate law all of a sudden. And it's quite the racket, really, to tell you the truth.
Probate is the most corrupt court in the country, my understanding.
Oh, my gosh. It's everybody's got their hand out and wants a piece of the action.
My contact information is my blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile, I have two of them, Sovereign Living and Sovereignty International. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group on Facebook called Sovereignty International is being deleted. It takes time to ban 17,000 people off your group, and I'm not going to let Facebook profit from my hard work. My Yahoo private group is called Administering Your Public Servants. My Google private group is called Administering Your Public Servants. Follow me at Twitter on Engineer Win, and follow me at VidMe at Sovereignty International, and follow me on Steemit at Sovereignty International. And check it out. And if you follow me on Steemit, I'll follow you back.
Yeah,
that is what it amounts to. Hey, we've got a caller.
Okay, let's take the call.
Wait, we had a caller. Not anymore.
Caller.
I guess they hung up. Maybe they didn't. Maybe they weren't calling it beyond.
Well, Glenn, when you were talking earlier about assigning, you were one of the assignees on a land patent. Not the blood heir, but you're claiming to be an assignee.
Yep.
Who gave you that assignment, if that's the proper term? And does the guy who assigns, does he have to be an heir who has legitimate claim on the land patent? Can he, or where does that assignment come from?
Well, everybody really is an assign, and so the fact that somebody sold me the land makes me an assign by definition. So I just claim it, basically.
You claim it, and nobody stands up to argue against you.
Yeah, exactly.
Yeah.
Hey,
do you think that's because people are ignorant, they're indifferent, or do you think it's such a hot potato nobody wants to talk about it? If you've claimed the land patent, fine, just let him have it and let's get out of here. We don't want to argue this issue from the court, from the perspective of the court. Do you think that's part of the deal or just indifference?
Well, Rice McLeod used to say that we could claim the neighbor's land if we want because they don't own it. So I haven't ever done that, quite frankly, tried to claim a land patent on somebody's land that I didn't have some interest in. But I mean, most of these people are just idiots when it comes to the land. And so you could, really, I mean, if they found out what you're doing, then there would be a fight in your hands. But
either that or they could make you an honorary attorney. Maybe even a judge. If you do it big enough, you could even be a judge.
Yeah, there you go. Hey, that's essentially what they do.
hey, we've got a caller back.
All right, let's try it. Hello, caller.
Deborah. Hi, how are you?
Deborah.
It's Deborah. Hey. Good show so far. I'm learning quite a bit. I've got a couple questions for your guest, if that's all right.
Go ahead.
Hi, my name's Deborah. How are you doing? Your name I'm sorry, what is your name again? The guest? Is it Gary?
Glenn.
Glenn. Hi, Glenn. How are you doing?
I'm doing well. How are you?
I'm doing great. I've got an interest in this topic for the evening, and I was listening to what you had said earlier about when you would go and you would pay in gold and silver, you would pay to have the land transferred. So who are you actually paying? Who are you paying the gold and silver to?
Well, originally, if you remember what I said, I would have a structure, a limited liability company or trust or somebody like that would buy the land from whoever's selling it, and then they would transfer it to me for the gold and silver coin.
And you would pay okay. I get you. You're creating this artificial entity to purchase the land from whoever's got it right now, and then you purchase it with gold or silver from that artificial entity.
Exactly.
Okay. So do you ever contact the original land owners who hold the land patent?
I'm sorry?
Do you ever contact when you find land that you want to purchase, this process that you just described? Do you ever find the original land patent holder of the land? Is that who you're trying to contact, or is that not even part of the process?
No, I just buy it from whoever owns it right now.
Owns it but not by true title, then, is what you're saying. They own it because of a warranty.
Yeah. He's saying he claims it after he purchases something relative to a parcel of land, and then he claims, here's what I own.
Okay.
And now it's up to someone to object, and if no one objects, then this theory in theory goes through.
So that's interesting because Go ahead.
Well, no. So what happens is that because, I mean, first of all, there's nobody that really has an interest in it. anybody, like as in the property tax thieves, they're just thieves, and so they don't want to, they're not going to say anything about it. And the Roman cult, that's just another gang of thieves, so they're not going to say anything about it. And really, if you think about it, I thought I was buying a land patent anyways. And so I'm just claiming something that I thought I had all the time anyways.
So are you just purchasing the surface rights? Because I know in Texas, because I do a lot of research on this, because I have found my family does hold a lot of land patents. And so, but when like the house I'm living in today, of course, we don't own the land under the house. In neighborhoods, we don't own the land patent or the minerals. But on my mortgage, it says surface rights only. So are you just purchasing the surface of these parcels of land, or are you purchasing I guess you're not purchasing the minerals too underneath the ground because you don't have the land patent, correct?
Actually, I mean, the minerals and the oil and all of that stuff, I mean, if you read about the oil, I mean, all the oil is under the law of capture, okay? That's admiralty. And so technically, when you own the land, you own the land to the center of the earth and to infinity in space. And
well,
so, absolutely.
That would be the original land patent, whoever it was assigned to by the President of the United States. That's who would own the minerals. But they own the surface, the minerals, the air, they own everything. So you're saying what you do is you come in, you find property that kind of that someone's selling, and then you pay in gold and silver, and so you get the minerals and the surface and the air above it. You get everything. Is that what you're saying?
Yeah, essentially, yeah. I mean, because all the mineral rights and all of that is color of law, anyways.
So what happens if the heirs ever came forward? If the heirs ever found out that the original land patent heirs, if they ever discovered that they had that land and they came forward, what would happen?
Well, first of all, somebody sold it, okay? So there's a chain of title. I've done some chain of title searches. I helped a friend it's in the DFW area, helped bring forward his land patent on his. He had basically a house on a city lot, and so I did for him. He paid me, and I went down and I did a title search, and I brought it back. I did the search the title back to the original land patent. And while I was down there, I met some of those people that Al was talking about that were working for these frackers, actually, doing title searches, doing exactly the same thing I was doing, because they wanted to be able to prove title. And so. Again, most everybody that's owned that land is dead, and the only people that are alive are the recent owners, and if they sold it, they sold it.
Interesting. All right. So just hypothetically, what happens if there was someone that's not dead, that is actually alive, and are you sure the title searches your title search, it goes all the way back to the sovereign, and every conveyance, everything is included in there in your land title search?
Well, I haven't done that on all of my land, but I'm not too worried about it. If I buy it off the current owner, again, it comes down to what's called marketable title. In order for someone to buy land, you got to have some essence of title, and so you can't just buy land that you don't have a right from someone that doesn't have a right to sell it. And every time land is transferred, there's some sort of a search that's done, especially if the banks are involved. And you can easily you can do it yourself. I haven't done it on every piece of land, but my attitude is that if somebody sold it, they sold it.
Right, but what if it sounds to me like the system, as we all know, is completely open for fraud, and these county records that are in our areas. There's no verification for anything. You can take in anything, and they're required to file it. You pay the filing fee. As long as it's notarized, they'll file whatever. And so isn't there a concern for possibly someone to come in that doesn't really have true ownership to that land, but does a quick claim or does some sort of claim and are conveyanced into where it appears on paper that they have title to the land, and then they end up selling it, but they don't. But there's land patent heirs that are in the picture here, but they're completely overlooked. Maybe they don't know that there's land, that they're heirs to the land yet, and someone else has come in and unlawfully claimed the land and then sold it in this chain of title. That's a concern. It would seem to me like that would be a concern for anyone buying a piece of land to make sure.
You're not an heir. You're not an heir to the land if your parents sold it. Your parents may have a land patent, but if they sold it, you're not an heir anymore.
These aren't sold, and usually when you look at the land records, most people who have land back in the day, they never sold their minerals. They would sever the surface from the minerals, and they would keep the minerals reserved to them in case there's any kind of oil or whatever in the ground. But they would sell the surface rights, but they would still reserve the minerals to them and to the heirs of the family. That's how. That's why when you look at almost every mortgage I've ever looked at, it always says surface rights only. Now, if you don't put the surface rights only on there, then it could actually get transferred, the minerals, the surface together. So, that's why you want to always look at your paperwork, and it always says surface rights only on there. So that means the minerals are reserved.
I've actually never seen that, but you're right in that. I don't buy property that's a subject of a tax sale or a foreclosure because that is a valid concern. But beyond that, I don't worry about it too much because, again, another thing that happens is that the county tax people are sometimes harassing you for extortion, and so what happens when you bring forward the land patent when it works properly is because there's actually statutes that say that they have to that you have to record your transfers, and I've even seen court cases that talk about it where someone didn't take their transfer down to the county recorder and get it recorded. And so you have to notify the county recorder, the land titles, wherever that happens to be in your state. But when you bring forward the land patent, what it does is it takes it off the tax roll. And so if it's done properly, they won't even want to talk to you. And so you will have notified them. You'll have proof that you notified them, and they won't want to talk to you. I've got a good example of that is, well, it's in Texas. Again, this is corruption going on, but this is some land that I brought forward the land patent on near Corsicana at one of these gated communities there. And what happened is they were harassing me for property taxes and homeowners associations dues and all sorts of garbage. And so I brought forward the land patent, and then I transferred it from the trust. It was owned by a trust, transferred it to myself, and served it on them by registered mail without the filing fee. And they sent it back saying that I hadn't paid the filing fee. So then what happened is the lawyers, they started getting the lawyers involved because they wanted their extortion, their property taxes, and their homeowners' dues, and all the rest of that. So these lawyers started soliciting me for the property taxes, and I sent a registered letter to the lawyers, and I said it was from me. They send their letter to the trust because under the county records, the trust still owns it. But even though I sent them the document showing that I owned it, the deed, they wouldn't file it because I didn't pay the extortion. And they sent it back. So in their records, it shows the trust owns it. So every year I get a letter from these liars saying that all these property taxes are due, but they never ever do anything beyond that. They haven't tried to sell it at a tax sale. They haven't done, and I sent them a letter and I said, I sent them from me this time, and I told them, you sell that and you're going to be personally liable, and I'll come after you, and it's going to be your worst nightmare. Here's my proof that this is owned by me, and I don't care what your records show. And I basically let them know in no uncertain terms that they were personally responsible. So all they do is they harass me with these tax notices. All they do, and that's all that ever happens.
Could it be
I suppose they're
possibly
charging someone to send those tax notices to you. It's not just harassment; it's paid harassment. It'd be a guess.
Well, I've got a question.
Oh, yeah.
Are they? Let me ask a question. Are they sending you? If you were an heir to that land, the land that you purchased, would that still be happening, or is it possibly because you're not a true heir, you're claiming ownership to the land, you brought the land patent forward, you're trying to get it to where you have full clear title like you would if you were an heir, basically. But since you're not an heir, could that be possibly the problem on why they're trying to, because that's what I think is going on. The reason why we have to pay property taxes on our, all these neighborhoods is because we don't own the land underneath our houses. Neither does the state, really, until if the heirs ever came forward and showed that they're the heirs of the original land patent, then I guess we'd have to pay taxes to the heirs, not to the state, But it just seems to me like that's the missing link here is the land patent.
In land patents, heir and assignee are equal. One doesn't have any greater claim than the other.
Only the person who can do the assigning is either an heir or the land patent, the original land patent owner, which is usually by this time they're dead. But not just anyone could come in and assign that land over, because the true holder of title is the land patent owner.
Well, there is no. When I was down, there is no form to change a land patent. You cannot go and say, look, my name's right on here, and now I want to pass this land patent on to my son over here, so I want you to take my name off and put his name on. You can't have it done. They won't do it. There's no way. So it's not an actual piece of paper. It is the rights. That's all that's the land patent. It's the rights.
But they're signed by these patents are signed. They're very big. These patents that's the true piece of title. If you want to have a title to something, the land, that's the actual patent, because they're signed by the President of the United States, and they're archived in
my main thing about the land patent with the government, okay, because they're really the problem. It's not the heirs or the assignees, it's the government is the problem, and they just want to extort money out of people. But the bottom line with the land patent is, you go down, you claim the rights to it, but you chain your title and say, look, I bought this. This is chained all the way to me. This is the transfer, and I'm claiming the patented rights. Now, they can say, oh, no, you don't have that. Oh, no, you're not this. Oh, no, you're not that. Well, that's fine, because neither are you. So what are you doing here? Why are you talking to me? You've got no claim. You can say all you want that it isn't me, but I know it isn't you.
Right. Well, that's the problem. I'm talking about when you're the original, when you're really a true heir to the land patent. And,
most of those people are dead, Deborah. They've been dead 100 years.
I'm not dead. My great-grandparents have a lot of land patents, and my great-great-grandparents have. Most people don't even know who their great-great-grandparents.
They never sold any of that land.
Oh gosh, no. They back in that time, they never sold. No, they never sold the land. The land patent, you can look in the actual records and see from 1900, and then there'll be a dead space. There'll be because every time you do any kind of transaction on the land, when you own the land, you go in and you fill it on the plat book. If you're going to transfer it, you're going to convey it, quit claim it, whatever, you record it, so you physically handwrite it in what's called a plat book. So you can actually, when you're researching into the records, a real true research to where you're really diligently going back to the sovereign, the land patent holder, you get that plat book out and you look at the plat book and you see who all has, had their hands on the land. Well, you'll see in 1920, at the very latest, 19 maybe 30s, and then you'll see dead space for 60, 70, 80 years. You'll see nothing. There's been no recording or anything. Then all of a sudden, in my situation, you see about 2000, 2001, you start seeing people coming in and claiming this land that are not even part of the family. And so it's pretty interesting when you start doing your family research and you start seeing all these other hands and your dead, your great-great-grandparents' land, and it says on the land patent, just like y'all said, it says heirs and assigns forever. So that land patent never expires. There's no statute of limitations. The heirs can come forward whenever and claim that their rightful claim to their family's land. And so That's where I'm sitting at. I'm not trying to claim other
people's land. So if your
land
grandparents sold the land, but with a warranty deed to somebody who actually thought they were buying the land, you think you can go back and say, "Hi, I'm the heir. Get out."
What are you not hearing? I never said they did not sell the land.
I'm not talking about your specific situation.
Okay.
This is a generalized thing to where, if you are an heir, okay. But the thing is, people sold land.
It's very messy. It's a very strange situation, and it's a certain amount. Some of this is like playing liar's poker.
That's not right.
I can claim to have a land patent, and somebody else can claim to have the land patent, and who's really got it? It becomes a mess. The whole system, it seems to me, it goes back to this idea that the land and the real estate are two different things. And most of what's bought and sold today is real estate, and if you make a claim on the land, all of a sudden you're threatening a system. You're not just going after a couple acres of land someplace. That's not what's going on. You might be going after a couple 100 acres of land. I don't care. But it's not just you're threatening the whole system when you bring this land patent up. You're threatening the idea of real estate. And if this thing really went to court with someone who knew the law and could argue it in court, it could be maybe revolutionary.
Check out my other videos, Bankster Thieves playlist, Roman Cult playlist, Bankrupt Corporate So-Called Governments, Bar Members 1 through 3, Do-It-Yourself How Not to Volunteer for the Selective Service in the Draft, Martial Law is Here, Do-It-Yourself No Income Tax, Do-It-Yourself Free Mail 1 and 2, Do-It-Yourself Kangaroo Courts 1 through 9, Canada Border Pigs playlist, Bar Members and Their Satanic Connections playlist.
Well, that's where I'm sitting at, because my family, they're 12 brothers and sisters on each side of the families, and they were part of the land run, the Oklahoma land run. Just when they opened up the civilized the Cherokee land strip out there in Osage Territory in Oklahoma, and this was a historical event, and people came from all over the globe, and they literally got on their horses and staked their claim of land, and these are 160-acre plats of land. And right there on Osage Territory. And so this is this is how America has started. This is what it's all about, is land ownership. Mm-hmm. So, it's a very, very important, and you can't, just like I agree, you cannot be free unless you own your own land. We can sit and say we're free and try to fight for our gun rights and all this other stuff, which is all very important too. But without the ownership of land, where can you be free? Because that land is your kingdom, and that's how we get our freedom. So
this country started out with a familiar phrase. Everyone's heard it. A man's home is his castle. Well, maybe that's not just a metaphor in the sense of, it's your castle. You even got just a little hut, it's your castle. No, I think it means when they started this country out, you owned it as a sovereign.
Exactly.
And it really was your castle. It was the castle in the same sense that the Duke's house was his castle over in England or whatever. The sovereign got to own the land, and I think that was what maybe was implied by, your man's home is his castle. Maybe that was part of the original implication. I don't think it's true today.
And the land, like Deborah said, land patents are 160-acre parcels. Now, people don't own necessarily 160-acre places anymore. Somebody might have a 50-acre, 25-acre, 10-acre. So it's not really, and they've never issued patents in anything other than 160 acres. So, there has to be a way to transfer the rights of the patent to the assignees.
Who's assigning it, though? Who's actually assigning it? That's what I'm trying to understand here. Because the assignees can only be assigned by the land patent holder. Everyone else is a color of title. They don't have true ownership. And if there's an heir alive to the land, wherever it may be, whatever state, Texas is a very different. Most of the land that I've been researching is not in Texas. We have Texas land, too, but they're actually called land grants in Texas. But the land patents, the rest of the country is in land patent form. And if you don't own that land, the government, no city official, no neighbor, nobody should be coming in and assigning that land to themselves or to somebody else because they don't hold the patent.
Well, not every piece of land, not every land sale was written down in a book or recorded at the thing, in the 1900s. No, it wasn't.
Yes, it was.
No, it really wasn't, Deborah. People made all kinds of things. Guys would get drunk and lose their land in poker games.
Exactly. I agree with you, but I'm telling you right now, if you ever take time to do diligent research in the land records, you will see everything is, because land was everything in their days. That was their wealth.
Still is if people really know what's going on. It still is, and we are so removed. This is a good question for Glenn, for example. Why are we so ignorant about land patents?
Because, I can answer that.
If you look at them, the average person, if you think about it at all, you think this is something archaic. Something that went back to the 18th century, and, it was something they did back then, but now we're modern and we don't need those anymore. Why do you suppose people are so ignorant? And when I say people, heirs. How come the guy, Grandpa left some land patents? What happened to Dad? Why didn't he figure out the significance, or the grandchildren? Why hasn't this passed down from generation to generation in a meaningful and intelligent, knowledgeable way?
Well, my answer to you, you're absolutely correct, and it's part of the way, unfortunately, as we all know, our country has been literally dumbed down, and I believe, with my own opinion, if that even matters, is that this is the reason why. Because if the government or the powers that be, whatever you want to call them, if they really want to enslave us, and nobody pays attention to land anymore, but it's the most important thing. It's the most critical it's between us and God, really. But without land ownership, and if we don't do something about it now, this next generation, because I became aware of my family situation, and you're right, most people are clueless to what even a land patent is, and I think that's been done by design. We were not taught about it. Real estate's now is what it is, and that's because these heirs are not even aware of who their great-grandparents are. Most people don't know their grandparents' maiden names, their great-grandmothers, and they don't even know their last names, and I believe that was done by design for this very reason, to enslave us, because eventually the government and these big bankers, these big corporations, they're going to eventually claim an ownership to all of it, and then nobody will have any, no one's going to know who their heirs were.
Well, what you're saying, among other things, is you're saying you've got to do, in order to make an effective claim on a land patent, you're at least suggesting that you have to get deep into the concept of genealogy, where you can track your own heirs back, or your
bloodline.
Your bloodline into the past and so on. But let me see what Glenn has to say about this. Glenn, why are people so ignorant?
Oh, I think it's because of the liars and the bar and the Roman cult. Quite frankly, I think Deborah is 100% correct. They're trying to enslave us, and because I agree that land is absolutely crucial to everything. And even if you only own a city lot, you still own some land. Now, you can never change the land patent. I've never seen anybody. Now, the government does, what they'll do is they'll sell the land, and then they'll wind up back in possession of it, and then they'll sell it again. So then you'll see land patents on the same piece of land separated by many years, but once that land patent is issued,
wait a second,
it will never be changed.
Let me see if I understand correctly. You're saying that you can see more than one land patent on the same section of land?
No.
One that was issued, say, 1820, another one that was issued 1920. Are you saying that's conceivable or not?
Yes, I've seen that, and the reason is that they wind up back in possession of the land. They buy it, or it gets seized, or whatever, and so then they sell it again. And so that happens, but once that patent is issued, it will never be changed. And whoever I'm going to sign on my land, whoever a deed basically is a notice of assignment. Now, it is true that it is a color of title, and the land patent is the highest and best title. But even the courts have ruled that a land patent it's a quitclaim deed, because the real people that own the land in this country are the First Nations people. And so, it's the highest and best title. That's what it is. And I'm an assign. You're either an heir or an assign. You cannot be both. And so it either goes to the heirs or the assign. So I'm an assign. I don't expect that an heir is going to show up. If they do, I suppose I'll deal with it. But I don't expect that any will show up. But I own several pieces, multiple pieces. As a matter of fact, one piece in West Texas, I went and got into I got two pieces actually in Hudspeth County in Texas, and they wanted their extortion. And what I did is I built a case against them, like I do with my notice and demands, and then I filed a criminal complaint. And when I filed a criminal complaint, I sent it to the Texas Attorney General, and they kept harassing me for the extortion. So then I went and added the Texas Attorney General to another criminal complaint as a co-conspirator and sent it to the U.S. Attorney, and then it all went silent. Okay, never heard another word from them, never got a tax notice, never got anything from them. And that's on a 10-acre parcel and a 20-acre parcel in West Texas out in Hudspeth County. And so, again, you have to assert yourself and be prepared to drag their butt into court and build a case against them. And many of our public servants, we have a lot of good, honorable people that are public servants, and they will honor their oaths if you present the right issues for them. And so that's the key, is to build a case against them and then present that case to people that have authority to take care of it for you.
What if you see on the chain of title when you're an heir that you have literally there's banks that have taken over the land? There's banks on part of the chain of title. What do you do then?
Did they take over the land or over the real estate?
Well, it's really real estate. Yeah, no. What's interesting in my situation is I never see, nobody even touches or even mentions the land patent, the true heirs or the land patent. They're just coming in and like kind of like what you're doing is just, making themselves an assign and just, they just took it. And this has a lot of oil in the ground too. This is not just regular, it has, worth quite a bit of money. But, that's what's going on with my situation. So have you ever worked with just a regular heir, or is all of your work pretty much just making yourself the assigner and then taking it from that point on? Have you ever had any heir dealings with a land patent before?
I've dealt with a lot of them. I've collected a lot of them over the years. I've helped people. I have actually friends of mine on a Skype group that they're First Nations people, and they have some land in Louisiana that was essentially stolen from them, and they're in the process of trying to get it back. And I helped them. I've been helping them with documents and stuff like that. But my attitude is that we're all in this situation because of our own ignorance, and so. I'm not going to go and do a bunch of work for somebody for nothing, because part of the learning process of getting ourselves out of the problem is finding out what we did to get ourselves into the problem so we don't do it again. And so I like to let people, I'll help you with, I'll send you some documents that you can manipulate and create a lawsuit or create a criminal complaint, but I leave it up to you unless you're going to send me some sort of a donation to help you put that stuff together. I let the people do it themselves, and that helps.
I'm all about doing it myself. I'm all about doing everything myself. I'm very, very fine with doing it. I do a lot of legal stuff myself. So, but let me ask you one more question, then I'll get off the phone. Have you ever heard of a declaration of land patent, to file that into the county records and to use as like a notice that you're an heir stepping forward? I've heard it's called a declaration of land patent ownership, or declaration of heir to a land patent. you ever heard of that before? It's basically bringing the patent forward.
Actually, I have a document. I'm looking for it right now. It's similar to what you're talking about. It's a let me think. It's a document that basically says that you thought that you were getting the land patent and you're claiming it, but it's actually very well written, and I've given it to people to try and get their assert themselves as far as their land is concerned. It's a confirmatory instrument, is what it's called.
Doesn't this deal in, if you're the actual heir to the land patent, isn't this under treaty law? Isn't it protected by treaty? The actual land patent, the owner or the land patent owner of the true title of the land patent. I believe it's under treaty law. Is what I've
you know why that
learned.
might be true? Because the one who buys that land originally receives the land patent, the original land patent holder. He owns perfect title to the land, which means he may be functioning as a sovereign.
Exactly.
And it may be that the government deals with sovereigns by treaty law rather than by normal legislation, if you catch my drift. I mean, if I had a land patent on 160 acres, do I own that again as if it was my little dukedom? Do I own it as if I'm a sovereign? And if I do they have to deal with me by treaty law rather than just conventional legislation? Do you have an opinion on
treaty law? Yeah.
Glenn, do you have an opinion on that?
I think that you're probably right because you have to agree. Everything's by consent, and if you're agreeing with another sovereign, then it's got to be a treaty. But as far as what Deborah's talking about, it depends on which state you're in. Okay, because like Texas, I'm not sure would fall under treaty law since Texas was originally a republic, but if you talk about like Arizona or anywhere like it's related to the Treaty of Hidalgo, then it would definitely there's clauses in those treaties that talk about that kind of stuff, and so then it applies.
Well, the land patents that I've got in my family, that actually says on there's an act of Congress that was, there's 3 different kinds of land patents. There's a military land patent that you got when your family member served in the military. The government gave 160-acre tracts to anyone that was in the military revolution and things like that. And then there's a homestead patent with, the original homesteaders. And then there's an actual cash patent that you actually paid. It was $1 per acre back when the government was, surveyed all the other states and sold the land to the public. So it was $1 an acre for the cash patents, and the other 2 were, like I said, military or homestead. So, but each of these different 3 different kinds of patents actually have an act of Congress on them. So that would be, in my own personal legal research, I would think that that's under that protection of that act. That should be the law that I should argue or bring up to because I'm in the process of trying to come back in and claim my heirship, which is very simple to do because I'm an heir. I can prove it through DNA. So I'm asking you the question: would you use that act that's on the actual patent as your legal argument, your legal standing for reclaiming it?
Yeah, sure. Why not? If you can tie an act of Congress into it, then absolutely. Matter of fact, my latest YouTube video about land patents talks about there's congressional record where Congress intended that there be quote unquote unembarrassed freeholders. That was where the land could not be seized for any debt or anything. Once the land is paid for, you have absolute title, and it is extremely powerful.
And even some of these land patents that I have, it says not just the heirs, it says the heirs of the heirs of the heirs. It says it 3 times, so it says for the heirs of the heirs of the heirs, and it says forever. And so that
I got another question here for Glenn, Deborah, Frank, anybody who wants to answer it. When you see a land patent and it says this land patent belongs to I don't think the word belongs up here, but this land patent extends to the heirs.
Granted.
All right, granted to the heirs or granted to the grantor's heirs and or assigns forever. When it says that this is a function, and I'm just doing this from memory, and I might not be remembering it right, but if it says the grantor's heirs, okay, the grantor's heirs could go through multiple generations. But what about the grantor's assigns? And what I mean by that, when the grantor dies, can the next generation of heirs, do they get to assign this?
That's what the heirs is. That's why it says heirs of the heirs. That's why you're an heir.
In theory, the heirs could sell it. They could assign it to someone else. But can they, if the document says it's the grantor's heirs or assigns? The grantor's assigns, not the grantor's heirs assigns. I mean, it's a silly question, maybe, and maybe I'm not even making it. Maybe it doesn't even sound like it's making much sense. But can subsequent generations of heirs assign the property under the strict terms of the... Okay.
Yeah, absolutely. Yeah, I mean, they do that all the time.
But this is the way it works. So when you just think about it like this: when you have a big piece of land, 160 acres, and you want to make money off of it, because land is, back in that time frame, I mean, it still is, but people just don't understand it. But land is everything. So it would be complete idiotic people never sold the entire. Maybe they do now, or they do it under a color of title, but they would just sell the surface only because they would still profit off of that land. And so they would never at that time, they never sold the entire piece of land off. They just bought it from the government for $1 an acre. So these big parcels of land are these big, townships basically, or these sections of land are still in that, the land patent's original power. So, but yeah, they can sell the surface of it, but that's why most of the minerals today that in my research, the minerals are always are still owned by the original land patent owner. People just don't get rid of the minerals, but they can sell the surface rights. So,
but if that land patent owner is no longer available, or his heirs are no longer discoverable, who owns the mineral rights then?
Well, that's a good
Are they
question.
just there to be grabbed by anybody who grabs them?
That's why you have to be responsible landowners and know that if your bloodline is fixing to end, then I would assume that you would have to at that point assign it to whoever you want to assign it to, so it doesn't go into the state's hands or to the government's hands. But that's where my concern is, because generations are dying off. I know my father's the last of his generation; he's the last male, and so if we don't get our situation taken care of, then who's going to own the land? Someone's going to come in and steal it all, which they already have, but if we don't get it under control, then eventually the governments or the banks are going to own it. And that's going to be like that across the entire country. If people don't pay attention and wake up and realize that, look into your family bloodline and see if you have any land patents in your family history. I think it's really important to do that.
And I get that. And again, you're saying that you need to study your genealogy a little bit. And maybe more than a little bit, but you need to go back a few generations and find out what your grandparents, maybe Grandpa bought some land back in the day. Maybe he's got maybe your great-grandfather has 160 acres, or who knows?
Even
multiples of 160.
Even slaves back then were granted land. I mean, you'd be surprised on how many people probably own land in their family and they're not even aware of it. That's why I think it's critical for everyone to trace their family. It's not that far off either. It's just my great-great-grandparents and their parents. So my great-great-great-grandparents. That's the time when America was opened up and the government, sold it to the people. So anyway, but I'll let you end the show. Thanks for your information. It was very interesting, and thanks for letting me call in. And I'll let you guys get back to the ending of the show. Thank you. Good night.
We'll see you there.
Thanks. Bye-bye.
Thank you. Thank you.
We're down to the last 5 minutes of the program, Glenn. What would you like to add that we haven't touched on yet?
I wanted to make one point before we do close it up, and that's, we've talked about the property taxes quite a bit, and using the land patent to basically avoid that. But there's also another thing, and that's the zoning and the building permits and all that stuff. That all stops too when you have a land patent.
Well, here's the last question maybe for Glenn. I'm living in a house that I don't own land patent to. All right? I have no claim on it. But what if I could find the land patent for the location of this house? Would that land patent prove that this land was still within the borders of the state of Texas, and it was within the state of the Union, and therefore the land is not taxable, even though I don't own the land patent, and I make a claim that says this land is not taxable because it's within the borders of the state of Texas? If you follow what I'm saying, is that a reasonable idea or Patriot rabbit trail?
Actually, I've done exactly that. I helped a friend of mine in Easel, Texas, do exactly that. And what you do is you go to the Texas Land Commission, or first of all, you go down to the county tax assessor, and you need the survey number, okay? The survey number is going to be basically the number of the original land patent that was issued by the state or the Republic of Texas, depending on how far back it goes. And then once you have that survey number, you can call up the Texas Land Commissioner's office and give them a credit card over the phone, and for $5 they'll send you a certified copy of the original land patent. And then you just do a deed bringing forward all the rights and privileges of the original land patent. That's what I would do, quite frankly.
I did a declaration of land patent, and I got and I've got it in a file cabinet around here somewhere. I got a letter both from the United States Department of Interior and also the state of Oregon, and both of them wrote me back and said, we have no interest in your land.
That's wonderful.
Not that, like, we don't care about your land, but we have no ownership interest in your land.
Great.
I actually, put them in, what do you call that, plastic?
Yeah.
I
understand.
Heat them into plastic. That's
something to hang on to for sure. Put it into plastic and put it into a fireproof safe. I mean, that's the kind of evidence that you can hand down to future generations and keep the property off the tax rolls.
You know what though? My property, they still send me tax bills, and I've got this. My way is to say, look, I will pay the property tax as long as I can, and when I can't, then I won't. And then you'll just have to come and try to get me off of this land. But, the bottom line is, why I brought up the building permits and stuff is because that's what affects me most. Because, see, I want to do what I want to do without encumberment from the government. And it seems to have worked in that respect.
We've got about a minute left. Glenn, why don't you give people some contact information if you want to be contacted? How do people get a hold of you if they're interested in the subject and they want more information?
Sure. My email address is engineerwin, that's ENGINEERWIN @yahoo.com. I've got a Yahoo, or I should say a YouTube channel called Sovereign Living. That's all lowercase, all one word. I've also got another YouTube channel called Sovereignty International, but that's a subscription-based channel. I've got a private group at Yahoo and Google called, both of them are called the same thing. They're both called Administrating Your Public Servants. Those are separate words at Yahoo groups and Google groups. I've got a VidMe channel called Sovereignty International.
We're going to have to let it go at that because we're down to the last 5 seconds here, Glenn. I want to thank you very much for being on the program. I really enjoyed the discussion. I hope a lot of people learned a great deal. And Frank and I will be back next Tuesday. In the meantime, the good Lord bless you and me and Frank and Glenn and Deborah. Good night, folks.